I think one of the interesting sort of segues that I was hoping to do, but if you were at the policy discussion earlier with Congresswoman Mace and the Blockchain Association, a lot of that content was around where we should be going, right? And so what I kind of wanted to use this discussion to do was say, that's great. It's sort of relatively hypothetical. What's happening right now, and what are the actual sort of rules and regulations that you should comply with if you're trying to do something with digital assets, which has very broad interpretations. What I wanted to ask the panel to start was, how have you seen founders or consumers of crypto, either embrace regulation or ask more regulatory questions and not maybe necessarily just go to Panama and try to sort it out?
It depends.
It depends, yeah. But so what has that experience been like, for you guys having been in the space for a while? Like, how are you seeing consumer and founder sentiment towards regulation?
Sure. It's a great question. I'm sure we could talk about that for hours. I've seen a few different flavors. Early on, a few years ago, most founders were most concerned with figuring out a way to avoid U.S. regulatory requirements. How can we structure so we don't have to worry about securities laws, commodities laws, or money transmitter, anything else? So there are really two ways to do that. Move offshore and also not only operate from outside of the US, but exclude US investors or US participants. The other way is to assess the regulatory landscape, decide a certain amount of risk you want to take, and proceed with taking a certain amount of legal risk. I think the other thing that's happened, and I'll really be interested in everybody else's experiences, is that some of the businesses operating in the space now are really trying to attract financial institutions, US investors, and high net worth individuals, and they come more from the banking and hedge fund side, and they say, we want to take a zero tolerance approach to regulatory compliance. We want to be as compliant as possible because we know that our potential investors need us to be able to say we're complying with all regulations. We can be a security, we can be a money transmitter, tell us what we need to do and we want to do it. And sometimes that's easy, and sometimes that's actually very difficult because the regulation is uncertain. And so even for the best client in the world that wants to sit down with the regulators and say, tell me what to do and I'll do it, there are not that many answers.
Amen. Okay, so first and foremost, I apologize. I should have did the lawyer exclaimer thing. None of this is legal advice. None of this is financial advice.
I forgot to do that. Too.
Yeah,
I was going to.
That whole thing.
That too.
Don't do any of that. Or you'll have to pay us a bunch of money later when we have to unscrew what you've done. So, yes, the answer is yes. We got a lot of early, hey, how do we avoid regulation? Hey, if I go to Panama, hey, I go to BVI, hey, if I go to Singapore, and stay away from the U.S., does that count? And in a lot of ways it doesn't, right? Because the U.S. is a very powerful entity and it tries to get what we call long-arm jurisdiction over anyone and everyone. Now, I have some very fun fights with regulators about why that's stupid, why your cases are absolute and utter bullshit, and sometimes using that language because I am a corporate securities attorney and what I say matters as a gatekeeper per the SEC, and I love throwing that in their face. And so we try to do the best we can with the information we have. But right now we have very, very bad information. And so each one of us is a little soldier with our army going before these very, very powerful entities that have unlimited amounts of money and unlimited amounts of resources. And they just look at us like little ants, regardless of firm size or ability, and go, no. We go, what do you mean no? Like, we still have to move forward. We have to do these things. This client wants to, innovate. They want to, or they're going to leave. And so we're in this really hard position right now where we don't have a lot of answers. We're trying to find them. We're mixing and mingling and hot wiring, securities laws together with financial money transmission laws, with CMA laws, and the Commodities Future Exchange Commission all of a sudden decides that anything it licks or touches, it's theirs. And we go, that's cool, but tell us how to register it. And they go, ooh, we didn't think that far. Hold on, give us a minute. So it is a max of we try, depending on what you're doing, to get you as compliant with the law as we can. and then we promise you after you pay a bunch of money that it may not work out for you for 6 months to a year.
Sometimes we promise we say that before you pay.
Yeah, she didn't want that on record.
Brandi, did you want to add something that I haven't? Yeah.
My experience is a little different. Not as an attorney, but as a consultant, and then also in-house as an outsourced CCO. So I'm one that is relying on the brilliant advice by attorneys like these folks here. But for us, it's really that matter of how can we comply, and it's difficult. There's a lot of gray area, so a lot of it's literally that risk-based approach. But many of our clients, when they come to us, the startup companies are the ones that are getting into a new area. They really do want to comply. They're asking the questions. What can we do to ensure that we're not going to get in trouble, or that we're following the proper guidance? And sometimes there's no clear answer to that. It's we can do the best. We can document. We can note the risk-based approach. And then if you are playing in this space, that has to carry you a long way, because sometimes there's just not a black and white answer.
Yeah, and so let's talk about what it means to be compliant for a second. So I'll direct John. What is the Howey test?
So it is an investment of money on behalf of others, or what you expect to have a third party basically do all the work for. And so what the SEC has determined as an investment of money basically means anything of value. And we continue to fight with them over that, because my famous example that we give on stage and stuff is, if I have a laundromat or an arcade and I have a token, right, and I'm outside on Queen Street trying to sell my token before I actually have the laundromat or the arcade, and there's nothing to put that token in, then that's a security all day and every day, right? But if I have a machine and that machine works, and you take that token and you put it in the machine, and it's not a financial transaction to make the thing go, but it's actually a functioning mechanism of the machine, then that's a utility. Now, the CFTC and I are fighting on whether the gas station down the street takes the token, and whether my landlord takes the token, or my mortgage company and all these other folks. But that's the basis of the Howey test, and how we continue to interpret it and then figure out, does this security then possibly morph into an Ethereum-like utility? And that is the ultimate question from the legal perspective that we do not have, and what the current dispute with Ripple is.
Yeah, and that was a great point about the regulators that are actually involved in the space, right? So you mentioned the CFTC. We talked about the SEC. I think digital assets, whether it's tokens or something more fungible or less fungible, is everybody, it's regulated by the SEC, the CFTC wants to get their hands in it. Who should, in your non-legal opinion, have a say in how to regulate your token, and why would you think that you would lean in favor of maybe that regulatory body over another one? Yeah, we can kick it off with Alex, yeah.
Sure. I'll start. I think, the popular answer in the space for many years has been, we want the CFTC to be our regulator as opposed to the SEC. The CFTC has had a reputation of being easier to work with, more interested in fostering innovation, really having a focus on anti-fraud rather than a focus on regulating and reporting requirements for particular transactions. For a long time, they haven't regulated, this is about to change, but they have not regulated spot transactions in commodities, meaning if we just trade commodities back and forth, that's not a transaction the CFTC cares about. So people for a long time have been saying, well, if we can get our digital assets to be classified as commodities, I can trade them back and forth, and as long as there's no fraud, there's no market manipulation, it's not a derivative of that digital asset, I should be able to trade freely and not worry about it. And so people have been driving in that direction. Lately, and I think we're going to get to it, the Uki DAO case, I'm going to say Uki for this room. The CFTC is, sort of stepping up its enforcement in the crypto space. So up until 2 weeks ago, I think I would have said CFTC all the way, and now I'm not so sure.
It depends. I mean, it really depends. We have a lot of good relationships with all of the regulators, I feel like. And at this point, it's just a matter of reasonable parties can disagree, and they don't have the power to necessarily effectuate the change. And I think that we're going to start seeing more and more very powerful entities possibly sue them. Even the smaller folks. The issue with Kim Kardashian, her touting rules, I think is absolutely hilarious and utter bullshit. You can't have touting for, I mean, she did do it, and she should have disclosed some of it, #sponge, #ad. But I don't think you can, and I'll fight this, and I have fought with GCs about this, and the SEC, but I don't think that you can have touting rules for non-securities. That's outside of their purview. And I will take that to my grave, and I'll argue that before a judge or jury, which is, what I tell them, that, if you want to go toe-to-toe, we'll go toe-to-toe.
I guess just to add one thing to what you were saying is the issue that people have, in addition to everything that you just said about the SEC, the issue that people have with the SEC is even if I'm willing to be fully compliant with securities laws and register my token or sell my token as a securities transaction, my crypto platform doesn't work if every time a digital asset moves in the platform, that's a securities transaction, which means that even if I'm willing to comply with the securities laws at issuance, which is fine, there's no way yet to comply with them on an ongoing basis and still make a blockchain ecosystem work. And that's why people have been talking about, could there be a time where my digital asset was a security but could become no longer a security because otherwise we can't function.
Yeah, so going back to the laundromat, right? Like as soon as that machine's there, it's no longer a security, right? Because there's a machine there that you can put it in. It started off as a security when I was selling it out on Queen Street and there was no machine. But as soon as there's a machine there, it's arguably no longer a security. That's the problem with Ethereum that is being disputed right now. And so that's never happened before in all of the history of securities dating back to the Dutch.
Yeah, and Alexandra made a great point. Just one of my favorite quotes that I've heard recently is, welcome to Web3, where every click is a taxable transaction, right? And so, Brandi, I'm wondering on the compliance side, would love to hear your thoughts about the question we're debating, but also, what are some of the implications that you're seeing sort of more broadly from a compliance or reporting perspective? Like, who are you supposed to talk to? How do you know? What's the guesswork? Like, how are you dealing with clients in that way?
Yeah, and so it becomes increasingly difficult because we do have many clients that are also kind of working in that space where the SEC has inquiries or investigations, and so they're asking a lot of questions and there's expectations. But the clients are saying to these guys' points, if there were clear guidelines and requirements, we're fully willing to comply, but you can't just change the game kind of midstream. And that's kind of what they're doing. And there's so much regulation by enforcement. And so it's like, how can you really enforce something that's not really a requirement or not known to us? And so that's where many of our clients get into that tough spot. They really do want to comply, but they don't know how.
Yeah, and so let's talk about that a bit. You guys are setting me up beautifully. So one of the recent things that happened was the SEC we're talking about this sort of retroactive enforcement, right, or regulation via enforcement action. The SEC charged an employee at Coinbase with insider trading, ostensibly for basically front-running 9 different tokens. Now, Coinbase actually has a policy that they don't list securities, right, because Bitcoin and Ethereum are judged to be under the purview of the CFTC. We'll see how that goes. But so Coinbase actually had to step up and say, no, these are not securities, and so they got involved in this fight as well. But it surprised the legal community. What do you guys think about how we can, I guess, correct that situation, or who needs to make the changes, and also just, frankly, why? Like, why is that the preferred method right now?
Okay, so let's all agree that being able to front run is bad, right? Unless you're a hedge fund or you've got all of these awesome opportunities as Robinhood does. And so I agree with Coinbase in the sense that we've got to figure out this as an ecosystem of what the bad actions are, right? Because using Tornado Cash because you don't want somebody tracking your transaction doesn't necessarily mean you're doing anything nefarious, right? But if I want to launder a bunch of money, it's really great for that too. And so those are the kind of things in Web3 that we have to do, not only as like professionals and industry professionals, but we need a lot of the people here to help us figure out. The young lady who's the CPA, God help you, because woof. Our tax lawyers are, God help them too. That's the kind of stuff that we really need more industry participants and more new minds thinking about this stuff, because we don't have the answers. If we had all the answers, there'd be a couple Bugattis parked out front, and we probably wouldn't be at this conference. No offense to Dennis and everybody, but we're trying, and we're trying the best we can, but there are reasonable minds that differentiate between what is this commodity, what is a security, what is this weird nebulous world of a financial digital instrument.
Well, the issue for Coinbase is that Coinbase has said publicly that they've been meeting with the SEC and they've been talking with the SEC and asking for clarity. And Coinbase has a policy where they review every digital asset that they list on Coinbase, and they determine in some way that it's not a security, so they can support and facilitate its sale. The reason for that is that Coinbase isn't registered with the SEC to facilitate transactions in securities. So by the SEC coming after the employee for front running and not stopping there and saying, oh, by the way, you committed insider trading of securities, the SEC had to reach the conclusion that the digital assets at issue were securities. And if you read the complaint, they went through it for 60 pages and applied the Howey test that we were alluding to earlier individually to 9 of the 25 tokens that they said the person traded. The other 16, they didn't say why they didn't think they were securities. They didn't say anything about them. But for these 9, they were securities, which means that if the employee was insider trading securities, Coinbase is facilitating the trading of securities, and Coinbase is now, in the SEC's crosshairs because they're an unlicensed broker-dealer or digital asset exchange. And so this is the problem that people have, because they have said, we have a policy, we've talked to the SEC about it, and we only find out that you disagree with it because of this one employee.
See, we have many clients that are also in that same boat as Coinbase. As a CCO, I have been through this process internally. What is our risk rating framework? What is our coin listing policy? And I have helped create those from a compliance and a CCO perspective. And we look at it, I'm sure, in a very similar manner. Internally, we partially use the Howey test, other factors to risk rate the coins, the likelihood, and so forth. But the problem is that most of those, they have not been formally deemed securities. So then how can you be insider trading something that's not actually a securities, which that's the question of the day, right?
How can you be touting if you're not touting securities? So, I mean, to require the legal opinion, right, is what Coinbase requires. Who is the largest American crypto exchange that there is, right? And so we write the legal opinions that go through the analysis, that dig into the minutia of whether we, deem this a utility token or a security, right? And so those types of headaches, the fact that the SEC knows that, they know they have big, powerful law firms writing these opinions, and for them to take that approach after all of these years, after being all, elbowy and rubby-dubby with everybody, is just an affront to everybody. And like I said, the regulators right now, I get it that they're fighting with each other and it's all, fun and sexy, but for the businesses out here that are in it, it really sucks. The reason that we can be in, good buildings like this and have a substantial financial market and a substantial real estate market and build dope things is because we have regulators in saying what size that door should be and what width of walls we should use.
And let's get a little more, not in the weeds, but let's get a little more specific. So we've been using this term digital assets, right? And we've talked about coins that are listed on Coinbase. I've worked with a lot of DAOs who may have a token, may not have a token yet, right? And we see NFTs, people saying, JPEGs, like that. I guess, who do you see this is not legal advice, who do you see, I guess, having the most complicated time as we go forward from a sort of, if we're, to break down something like a utility token, a governance token, versus something like an NFT, or just a regular old, Bitcoin. who do you see as maybe having the easiest path forward, and then maybe something on the opposite end of the spectrum where you see a lot of gray or a storm out there at sea? Like what's your opinion on that?
From my perspective, I see a lot more gray when you get to utility. Just so with our internal framework, procedures, and process thinking, if it's a utility, but you can't use it for that particular utility, and you know that, then is that a problem? And so then is it a concern that it's not for the intended purpose, and now you have a problem on your hands?
Yes, that's a big problem.
I have a quick question. So, the conversations I've heard today, I've heard of Bitcoin in two different ways. It's either a bridge between transactions, or basically people are taking dollars, bridging it for a moment, and then converting it back to dollars or euros or whatever the hell they're selling it back to. And then the other option is the storage of wealth, basically, to basically hold as an investment. Is the actual mode of use a way to basically basically create the regulations about which way it should be, regulated?
It can be.
Yes, because I wonder if the use is if legally, like the legal term of the use of it versus what it actually is.
I think you could get 4 different answers
Yeah.
if everyone went through this. But I'd love to hear Alexandra. Yeah.
Sure. Just to answer your question, I think it's not necessarily the current use, which it's a great example. It's what is it designed to be used for? And then as a second part to that, whatever it's designed to be used for, can I use it for that right now? Or did I only sell it to you to raise money?
And I just to add to that, this may be an unpopular analogy, but I think it's one that's apt for a lot of these discussions. Unfortunately, is the people who make guns, right? They sell guns. They're not responsible for whether you store it in your closet or hang it over your mantle or do something terrible with it. And I think that's also changing, or there's interesting pieces of that analogy. But that's the intended use argument versus what I think we have an issue with is the issuers themselves are asking. They're saying, look, this is what we want to do with it, and it's okay until it's not okay, right? And so I think the Bitcoin is an interesting one because it was originally supposed to be sort of maybe a currency, right? And I know we're at the blockchain Bitcoin conference, so we're all fans here, but it was supposed to facilitate transactions, and then it skyrocketed in value, right? And not by the influence of one individual. And so I guess Bitcoin is interesting because the use cases have changed over time as the community matures, as the technology matures, as people attach things to it, right? As it becomes easier to transfer. So I think that's a very important distinction: the intended use versus how it actually ends up being used.
Yeah, I mean, we're still so early in this world, right? When people issue DAO tokens and all of a sudden they increase in value, it's not because people give a shit about whether they can vote about some, monkey picture. I think the more interesting element of this and the bigger fight that we don't really talk about, and I can't say out loud because I scared Hester Pierce yesterday with it, but the intellectual property dispute, Hollywood and DC split a long time ago. And there's a couple exemptions in commodities laws that question whether even the CFTC has rights over intellectual property. And I think that is going to be the real brouhaha that the regulators aren't even ready for yet. Degens like you guys out there will figure out what I'm talking about and figure out what that could possibly mean, not only from fundraising perspectives, but investment perspectives or financing perspectives and transactionality perspectives. And it's going to be exciting. The next 2 to 3 years we're probably going to see this asset class, whether it's Bitcoin or others, completely kind of blow up in a number of good ways.
Yeah. Do you have a question?
I missed the memo. When did we all decide that front running was bad?
No comment.
Yeah. It's too many lawyers up here.
I actually have 2 questions. The first one relates to the Coinbase case. So at what point, I guess I'm not an attorney, so if I'm watching it, at what point does them naming the 9 securities really matter? I guess, is it once that case is ruled upon and the outcome of that, is that what we're looking for?
I think it matters. It depends on who you're asking, right? Because there are several stakeholders there, right? So we mentioned UkiDAO earlier. UkiDAO is basically a decentralized exchange. It had a founding team. They formed an LLC. They didn't incorporate the DAO. They didn't do what's called a legal wrapper on the DAO, and so they issued a bunch of tokens. The two founders of the DAO basically settled with the CFTC like very quickly for a couple $100,000. All the token holders now, the CFTC served by sending something basically through their like help at DAO channel, which is also very sketchy. But so to go back to the Coinbase thing, all of basically the Coinbase ruling, the action, and we will see it litigated, right? I think some of us are hopefully optimistic about how the Ripple suit is going, because every one of these actions establishes a precedent. It draws a new line in the sand. And so not only does it personally affect the token holders who know, like, now what, do I need to hire an accountant? Am I having to pay more taxes? Am I violating some law, right? There's the founders of the project who are now vulnerable because they think, oh, I accidentally issued an unregistered security. Now I might pay a ton in taxes. And then there's also, we've talked about Coinbase, the implications there, right? Like, what are we doing if a 80, well, what is it now, like 60 billion, whatever. If it's a $60 billion company, doesn't know what they're supposed to be doing. So I think that's the challenge. And I'm told we're out of time. So
Thank you so much, guys.
Thank you.
Thank you to the panelists. Thanks to Dennis. Thank you to you all for listening.